C'è un secondo qui? Vai ancora un po' più giù. Here we have the essential difference, and that shows you very clearly the options you would have. As a British or Irish citizen who's actually owner of an Italian property, you would have two options. I think it's evident now that according to Italian and English law, if you own a property, a real estate in Italy, it will be submitted to the Italian succession law. So you actually have two opportunities. The first opportunity is neglecting completely this topic and not drafting any Italian will. In such case, whenever you will die, the Italian rules will apply entirely. So your Italian property will be divided, will be actually attributed to your family members according to the Italian law. And I mean, I will show you precisely the way this happens, in full respect of the rights of the forced heirs. Now this, for some of you might be inconvenient. Why? Because you might have a son you didn't see for 10 years who married a young lady that you cannot stand, and you do not wish that your Italian property ends up in his hands. So in such case, I mean, you would be exposing yourself to a significant risk should you not decide to take some control of the situation, deciding to draft an Italian will. Drafting an Italian will obviously give you the possibility not to ignore, but at least to mitigate the effects of the so-called legitimate succession. Okay? So it's something one way, directly or indirectly, you will have somehow to take in consideration. If you do not do so, the Italian legislation will do it, and the Italian law will take in consideration 6 degrees of connection. If you actually have a very small family, and according to the Italian succession law principles, nobody will appear, you will be happy to know that your Italian property will become full ownership of the Italian state. So I don't know whether you find this news particularly reassuring or not. It's up to each one of you to evaluate. Just to give you a rough idea, the way the legitimate succession is organized in Italy, you can check out this presentation. Look, for example, in this case, you would have, I hope this is going to work. Okay. In case of presence of just one child, this child will be entitled to 50% of the Italian asset, and the other 50% will be part of the so-called disposable quota. Because what I forgot to mention before, according to the Italian legitimate succession, you do need to take in consideration some members of the family, but this does not involve that you have to testate 100% of your Italian asset, okay? The law simply states that you have to give a part of your Italian asset. And something that is extremely important to mention, and also it's something that might have substantial effects when delegating your legal advisor to draft your wills, is that the legitimate quota also could take in consideration donations that were given to your forced heirs during your life. Okay, so also those donations which could be defined and considered as anticipated testamentary provisions also will play a role. Just to give you an idea, if you have one child, then you would have 50% as reserved quota and 50% disposable. I mean, you can do with it whatever you want, basically. so you can actually attribute it to whomever you prefer. In case of 2 or more children, you would have 2/3 of the Italian asset as reserved quota, 1/3 would be disposable. In case of presence of just ascendants, you would have 1/3 of your Italian asset reserved for your ascendants and 2/3 disposable quota. In case of married partners, spouses, you would have 50%, which is by law designated to the surviving spouse, and 50% was disposable. Bear in mind, this is very important, together with the right to 50% of your Italian asset, the surviving spouse will also be entitled to the right to live, to keep habitation rights of the Italian property. And such rights will affect not the reserved quota, but will affect the disposable one, okay? So it goes on top, basically. If you have a married partner, one spouse, and a child, you would have 1/3 reserved quota for the child, 1/3 for the surviving spouse, and 1/3 would be disposable quota. Bearing in mind that you still have the right to live in the property for the surviving spouse. Now, we have another possibility: 2 or more children and a surviving spouse. Okay, you would have half of the property, 50% of the property would be reserved to the son. 1/4 would be reserved to the spouse. 1/4 would be the disposable. Once again, and this always applies when you have a spouse, the spouse will keep rights of use of the property.
Supposing you're not married.
Supposing you're not married, we will go through this aspect again. Supposing you're not married in this country, in inheritance law, it will not, you will not be entitled to right. In case you are separated, you will be entitled to inheritance rights up to the moment when you are divorced. Now, you need to take in consideration one other aspect. Also, under what circumstances you purchase the property. Because it should be the case that you purchase the property jointly. If you purchase it jointly, then obviously you have the right to use. But bear in mind that the 50% of the property will belong to you. 50% will belong to your partner, and your partner will have to be very attentive drafting his wills, because he might have some children, for example, and they might end up having rights on the 50% of the property he owns.